Hi, my name is Cecily Signol. I'm a registered nurse. I work with Vancouver Coastal Health, and we're here today talking about euthanasia and assisted suicide coming to Canada. So we have Dr. Will Johnston here from the Euthanasia Prevention Coalition of British Columbia, and he's here to discuss the decision that was made today by the BC Court of Appeal. Can you tell us about the Carter case, what that's all about?
Yeah, just a little bit of background. 20 years ago in Canada, there was a celebrated case called Rodriguez. In Rodriguez, the Supreme Court of Canada rejected the idea that there should be assisted suicide available to someone who requests it because of some difficulty in their lives. And so fast forward 20 years, and we had some complaints from Canadians who had gone to Switzerland to see the death of one of their older family members. The complaint was that the Canadian law should allow assisted suicide and euthanasia, and that there was no good reason under our Charter of Rights and Freedoms to prevent assisted suicide and euthanasia. And so what happened last year in the Carter case, quite a well-known case here in British Columbia, was that the lower court judge, Smith, allowed the plaintiffs to be successful in their claim that the criminal code was unconstitutional on this topic. They said that Section 241 of the Canadian Criminal Code was constitutionally invalid and should be struck down because it did not allow for a doctor to provide assisted suicide or euthanasia to a person who wished to have that done. And so this was appealed by the government to the British Columbia Court of Appeals. And just today we've been extremely encouraged to hear that the Court of Appeal has struck down the lower court ruling and has found that the reasoning used by the lower court judge to legalize assisted suicide and euthanasia in Canada was poor. Our system has trouble treating people properly already. If we introduce into the system an expectation that in really difficult situations that active killing or suicide is one of the available solutions, this possibility, this offer of assisted suicide will be dangling in front of every vulnerable person in the country who is in that position. So I think that it's understandable that our opponents are chafing at the fact that the appeal court has pointed out the flaws in their arguments, but we need to keep our eyes on the higher principle that it's the Charter protection, the Charter of Rights and Freedoms protection in Canada against being killed, that is the right to life, is not a trivial thing. It doesn't change based on your quality of life. There's a real Charter legal protection against you being killed, and that is there for to safeguard all of us. There's a significant danger in striking down part of the criminal code that was upheld by Parliament on several occasions in the past, most recently in 2010, when a vast majority of parliamentarians had a clear choice to vote for or against assisted suicide and euthanasia, and they rejected the law that was being proposed. And so I think that, first of all, the appeal court recognizes that there is a great deal of division over these issues. It recognizes that Section 241, the law against assisting a suicide, is there for a very good reason, and it has been upheld by our elected representatives several times. And so the lower court was clearly in error in striking down that part of the law and presuming that Parliament would be able to hold a nationwide debate and come to a nationwide consensus and then come to a political consensus within Parliament, all within the year that was suggested by the judge, or was mandated by the judge in the lower court case.
So can you leave us with a takeaway message from the appeal?
The takeaway message is that this is something which is far too complex and far too divided in our country to be decided by the quick decision of a trial court.